this big story. Three of them are not going to see the courtroom in this month, next month, not until August. That, of course, former Officer Tang, former Officer Lane, former Officer Tao. What's your thought on the bifurcation of these cases? Was it right? Should it have been done? What do you think?
You know, I think we talked about this. It might have been a little bit of a pretext for COVID restrictions. I don't know that that necessarily was the actual reason. I think that I think that there's a better chance of conviction if all four are together, and you hear the story together. And there's more likelihood that certain pieces of evidence get excluded when you have these defendants bifurcated out of this trial. Subject to the motions in limine today, there was also some that were brought about their statements because the opportunity does not exist for Chauvin to cross-examine them. So I think that it's problematic for the prosecution. Was it the right thing to do? I don't know the legal basis for why it was done, other than the pretext given about COVID. So
yeah, I think if you look at the central facts, you'd have to say, well, they're all kind of connected. So COVID was the reason, but I think you're right. I'm not sure it was the legitimate reason for doing it. What do you think the impact is going to be then of having Chauvin's case heard first, and what's the fallout on those guys in the summer?
It depends on the results of the Chauvin trial. 100%. If Chauvin gets convicted, then I think that there's probably deals to be made by the other defendants, potentially, or those cases go to trial. I think that the prosecution rethinks those other cases if Chauvin gets acquitted in this case.
Yeah, so, if he's acquitted, maybe somebody on that next jury wants to hold it against these three guys because Chauvin got off. Not everybody's getting off. That could cut that way, which would also be wrong, of course, but that's, some sense of human nature. So what about those officers appearing in this trial?
I don't think you'll see that at all. I think that I noticed that they were on the witness list. I don't think the prosecution can compel them to come because of the Fifth Amendment.
Yeah, and that's always a good question, because what do you do then? You call them up there, a big show, and then they say, I take the Fifth, and then they wander off. And not only is it, bad showmanship, but it gives the jury a weird feeling about them before they're even tried.
I think it also tells the jury you don't value your time. And jurors get very upset with attorneys that waste their time. And so when you have a lot of repetitive witnesses, or you just have something for show, like putting someone on the stand just to take the Fifth, I think that you end up alienating yourself from that jury, and that is problematic. You need to be credible in front of that jury, and attorneys already don't have a lot of credibility in front of jurors anyway. So I think it's a bad decision to do that.
What I wish I had learned in law school that I did learn later on practicing trial work is finding out that point where you've got the jury understanding what you need them to understand, but you haven't gone too far. You haven't annoyed them. I'm not sure there's a class for that, but there should be, because it is invaluable. Okay, stay where you are, Christa. We'll take a quick break here. Come back again. We're talking about the